Well, hello there and welcome to another edition of the Disability Law Show. Good to have you along. Stick around for the half hour. We try to teach you something each week we do the show. John Scholes, your host, and with me, Tamar Agopian from Samfiru, Tumarkin, LLP. You can always reach out to Tamar and her team anytime you would like. It's simple. Phone number's good, right? 1-855-821-5900. help@disabilityrights.ca. That would be the email address. We have a busy show for you today, as we always do. Our main topic, you're going to love this one tomorrow. It's easy for you to answer, so we're going to get to this. 3 key questions about appealing an LTD denial. We love that topic. If James was here, he'd be frothing at the mouth already, but we'll see what happens if he catches wind of this show for sure. That, a bunch of emails as well from you, so we'll get to all that stuff, but we always start off with something you've been working on tomorrow. What do you got this week?
And so this week again was really busy with lots of calls coming in, people asking questions about their disability claims and, you know, the free consults that we offer, John. And I wanted to highlight a situation, one individual situation, but this topic has come up in a couple of calls that I've had, and it relates to people who have taken up what I call hobbies, and I'm going to do air quotes on the hobbies, that then they have earned income from.
Hobbies that pay. We like those.
Hobbies that pay. And this has been something we've seen quite often through the COVID period. People who have taken on things like candle making or some crafting type work, and I say work loosely, and then have created a business out of it, but really as a source or an outlet of either supplementary income or as a source of mental health supports as people were going through the difficult times and the loneliness around COVID and this kind of thing. And so why I feature, there was an individual that I spoke with, she's in her 30s, she was off on disability, working as a dental hygienist, and so she had a wrist injury, very clear, physical injury, and couldn't use her arm or her hand to do the dental hygienist work that she was doing. And so she was approved and paid for LTD benefits for a period of time. And then through the conversations she was having with her adjuster, it was revealed. She had a conversation about, hey, by the way, I'm making soaps and, a little side. I use the word hustle loosely because, she's like, I truly called it a hobby. Oh. And then the next thing I know, I get a letter from my adjuster saying, we are putting your LTD benefits on pause. So they pause her benefits and they tell her they're going to investigate further as to what she has been up to with this other work. And so she had come to us in this phase thinking, my goodness, are my benefits going to be cut off? What's going to happen? And the starting point, of course, in my mind was, let me see your policy. And lo and behold, her disability policy had a test in which it said, yes, you are entitled to LTD benefits if you are totally disabled from your own occupation, which she was, and if you are not working in any other you're not performing any other work. And so the question became, does this hobby qualify as work? And I would argue, absolutely not. She said she's making maybe a few $1,000s a year doing this work, and that basically what she puts into it is what she gets out of it. So she's relatively flat. It's not a source of income per se for her, and it really was an outlet for her to do something to sort of get her through as she was disabled and not able to work. And frankly, she'd been doing this for a number of years anyway. Right. But she was concerned. And so I wanted to highlight her situation because this is something that is uncharted territory to some extent. There is case law, though, that says you can have some capacity to work, but if you are totally disabled from the essential duties of your occupation, then you still qualify for disability benefits. And so when you're working at doing something else, 8 hours a week perhaps, or sporadically through the year, but you do have a business like this individual did, and you're reporting business income, then you have to expect that the insurance company is going to probe it, okay? They're going to probe it, but are they entitled to cut you off on that basis? That's a whole different conversation. And so my advice to her was cooperate with them, cooperate with the insurance company. You always want to be open and honest with the insurer. You never want to hide information. No point, yeah. There is no point, and at the end of the day, it's going to put more eyeballs on your situation than it's worth, right? You've got enough trouble as it is with insurance companies, and they're very cynical. The last thing you want is for them to think that there's something, untoward or you're hiding information. By the same token, if they say that this now disentitles you to disability benefits because it constitutes work, well, then we're there. We're going to jump all over this. This is not a proper basis in my mind in her situation for her to be denied disability benefits. But there's a but to a but, and it's this. The policy also allows for an offset or a deduction. We know this. And so there's always a section that says this is what we're prepared to pay. And so other income from employment or work typically is a deduction from what you're entitled to for LTD. So the way that I see this being played out, at least in her situation, was that they're going to investigate, they're going to get the tax returns, they're going to realize it's not much money, but if they feel as though it fits within their policy to allow them for that credit, then they may kick back up the LTD benefits and take a deduction for the earnings or the income that she has received. It's a lot. It's a lot to consider, but one that I wanted to feature because I think that it is a little bit sticky for insurers to use these kinds of hobbies or outlets for stress and this kind of thing as a means to disentitle people for LTD benefits. And I thought it was somewhat shocking that they even paused her LTD benefits to give themselves the opportunity to actually further investigate when she had been, cooperating with them all along. And so if you're in this situation, please don't hesitate to contact us. Let's talk this through and see whether or not it's something we can do to help.
Do you think if the insurance company had known from the outset that she had this little side hobby, you think they would deny her before they even gave her benefit one?
I don't know if I'm entirely convinced by that. I think that, this is where you want to make sure that you are being open and honest. But if it's not a level of activity that's so prevalent, that is so something that you're doing all the time, I'm not sure how relevant it is, right? And she even said, it didn't even occur to me to say to them that this hobby that I'm making soaps is something that's really something in my day-to-day activity.
More therapeutic as far as she's concerned.
It's more therapeutic, John, exactly. And so, would it have changed their profile? Possibly, but should it have? No, I don't think so.
The website, Pocket Disability Lawyer, that's available for you anytime. You just type in some key information and it'll give you back where you should be starting a disability claim. But I know, Tamar, you can talk more about it because you've used it. You go through it all the time. What do you think about the PDL, the Pocket Disability Lawyer?
The PDL is fantastic. I like that acronym. Look, we were involved in building this. Our team really looked at a way to create a tool that we can allow people to get some fast, quick, simple information, no legal speak, and no obligation. It's efficient, and it allows you to plug and play, which I like. So there's drop-down menus, yes, no, answer a couple of simple questions, and then you get a fairly succinct, fairly detailed response on, do you have rights in a certain situation with your disability claim? Of course, there's the add-on of the employment side as well if you've got some questions on your severance claim. And then if you don't want to be contacted after that, that is absolutely okay. You close out your browser, totally anonymous. You can even click no that you don't want to be contacted, but at least it's a starting point for you to find out what are your rights. Levels the playing field a little bit with the insurers, in my opinion.
Again, pocketdisabilitylawyer.ca is where you'll find that. And then if you just simply go to disabilityrights.ca, Tamar, myself, Sivan, James, a whole host of us at the firm have been doing radio shows across the country in all kinds of markets for years and years. You can participate in those shows each week. You simply call that number on the radio station or call even 1-855-821-5900. And possibly your question will get played back here on this show and we'll talk about it. So let's do that, Tamar, from one of our radio shows. Let's get to our first phone call for this show.
I've been on LTD for quite some time now, and I'm wondering, if I get a severance package while on LTD, say the company lets me go, I know that it says in my policy that the insurance company wants to know if I receive any income like a severance package while they're paying me. At what point can the insurance company not come after my severance to draw it back?
Good question.
Very good question. And this touches a little bit on what I was talking about in my opening comments around the other individual and the other income. And so look, the first part of this that concerns me that I really want to put out there is that he's being terminated while he's on a disability leave. John, we work in disability law and employment law, and this is really a problem. This screened out to me as a situation where I want to set him up with a consultation on the employment side of our team, though people like myself and a few others on our team sort of practice in both areas. But really, there are employment rights here that need to be protected. And you want to make sure that you're getting an assessment there and the right firm to give you that advice so that you are protecting both your employment rights and your disability rights. So that was the first comment I wanted to make about this caller. The second part is this. Just because you're terminated doesn't mean that your LTD benefits should stop. In fact, it shouldn't stop at all if one has nothing to do with the other. And so you want to make sure that your LTD benefits are going to continue and that you're not concerned necessarily that now you've lost your job. You're not job attached, so to speak, so you won't have necessarily a job to go back to if your LTD benefits end, but the LTD decision should be separate and apart from your employer's decision in terminating you. But the core question is, well, at what point is my severance a deduction? Does the insurance company get a credit? And the policy is number one here. You want to get a copy of it. You can get a copy of it from your insurance company if you put it to them in writing. They're required to provide you with a copy, and so is your employer, by the way. And so get a copy of that policy, send it to me. It will take me less than 5 minutes to look at the right section and give you firm advice on whether or not your LTD insurer is entitled to get a credit for your severance. But the caller is absolutely right, John, that this is one where you have to be open and honest with your insurance company about income that's coming to you. And severance typically is one of those areas where it is an allowable credit. Exactly. And so you want to anticipate that your insurance company is going to take a credit of what you're getting as severance against what they're paying you for LTD. But the devil is in the details. So get that policy and see whether or not you can protect that credit or offset from the disability insurer. But don't not tell them. That's the one thing. The key takeaway is you want to make sure that you're advising the insurer and then sort of see where the chips land from there. And don't sign anything on the employment side until you get an employment consultation.
That employment side, it's interesting you just mentioned that at the end, because if it's the case where he was let go while being on disability leave, that could be a human rights violation. Human rights damages, can they be taken credit by the insurance company as well?
And so this is where the words matter.
Right.
The buckets of compensation that you're getting from your employer really matter as to whether or not your LTD insurer can get a credit for it. So what John is talking about is, and I call it bucket for a lack of a better term, but there are different elements of compensation that you would get if you are terminated wrongfully from your employer. And one of those areas is potentially what's called human rights damages. So it's not straight income, it's not termination pay, it's not severance pay, it's this other compensation element. And some disability policies don't include that level of damages or other compensation that you might get as a credit or a deduction. Vacation pay is actually one of those areas as well. And so this is why you want to make sure you're getting the right advice so that you know, is my LTD insurer taking more of a credit than they should? Because if they can, they will, even if they shouldn't. And so this is why the words really, really matter, and it matters how you're being compensated by your employer.
And with that, we'll get into a short break here. Stick around for it. When we come back, 3 key questions about appealing an LTD denial. You're going to love this one. I know Tamar can't wait to get at this topic. In the meantime, 1-855-821-5900 and help at disabilityrights.ca. Lots more of the Disability Law Show is coming right up. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show. So good to have you joining us this week. We hope you learned something. And if you have any other questions following the show, do not hesitate ever to reach out. Phone call is always good off the top, 1-855-821-5900. Help at disabilityrights.ca. Through email, want to get to our main topic for this one tomorrow. We love this one whenever it comes up. It's too bad James Fireman's not here. He loves talking about appeals.
We don't need him. We don't need him, John.
And that would be 3 key questions about appealing an LTD denial. We'll take it back to basics. What is an appeal and is is it a government-run process?
So what is an appeal? This is a process.
Other than a waste of time. Go ahead.
It is a waste of time. And, and I feel just as frustrated as James when this topic comes up, because it is one that's conceived of by the insurance companies. And I think it's to satisfy their regulators that there is some kind of a checks and balances that they have, where when they're denying disability claims, there's some other process that people can access in order to try and, change their mind, which here's why it's frustrating, because it's not in the disability policy. There is no oversight. This is not a government realm, and it's really something that is very process-driven by the insurer. And I say process-driven because I used to work for one of these big bad insurance companies, and I know exactly what goes into this process. And so typically you will have several levels of appeal, and at least at the first level, you're dealing with the exact same person who already said no to you. So it's human nature. You're now going to submit more information or a letter, or some kind of plea to the insurance company and the same adjuster who said no to you already on the same information that, look, you guys really made the wrong decision. Please just look at this again. Once a decision's been made, once the insurance companies cut you off, you're going to have a very, very hard road to climb to try and persuade them otherwise. But what they're doing is they're lulling you. They're trying to get you into that process with them, because it then really prevents people, I think, from exercising their legal rights. And that is what the insurers want, because once you start that legal process, it takes it out of the insurance company's hands, truly, and it puts it into the court realm. There are very strict rules around how they're supposed to respond. We can leverage a whole aspect of damages and other things that they would have done improperly against the insurer, and it puts it in the hands of one of their lawyers. And so it's no longer the same adjuster who said no to you perhaps more than once. And it really is, there are strict timeframes and things that have to be done in the legal process. That is what I don't like about appeals, along with the fact that it runs down that clock, right? And so in BC, Alberta, Ontario, and most of the other provinces that we practice in this country, there's a 2-year time frame to sue the insurance company. And this must seem like a very long time to people, but when they offer appeal after appeal, and they don't have a strict time frame in which to respond to you, it could be months before you get a response from the insurance company saying, okay, we've now made our final decision, and this is the end of the line, and so on and so forth. And in that time, they are running down that clock for you to actually exercise your legal rights. And this is the biggest challenge with this appeal process.
Well, I think the word appeal sounds very official. Everyone's thinking, courtroom appeal, maybe I have another shot at this. But especially, the first couple, if you're dealing with the same adjuster, it's like your kid comes to you a half hour before dinner, says, can I have a chocolate bar? No, you cannot. If you go back in a half hour, ask again, what's the answer going to be? No, you cannot.
That's right.
It's a similar type thing, right, with the appeal process.
It is. And I think that the only real exception, the only time where I would suggest to someone, look, maybe, you could file an appeal, maybe there's an outside chance of success, is if in fact there is some kind of absolutely new medical condition, something totally different, something that was not part of the original decision that the insurance company has made. That is the only narrow circumstance that I would say an appeal process may make some sense, because understandably, you want to make sure that the insurance company has the full picture before they make that decision. Right. And that really is what point 2 is about, right, John? Yeah. Is this idea of, should you
always do it? Yeah.
Should you always do it? And I think that I would say almost never, right? Almost never. And I know that's a lawyerly response, and I recognize that. But again, for all of the reasons that I described out of the gates, is that the cards are really stacked against people. And the way that you have that level playing field is when you start that legal claim, when you exercise those rights with the help of myself, someone on my team, because the insurance company can't ignore you. They have, like I said, they have to respond to you. They have to take a more even approach. They can't cherry pick. This is the other thing, John, and this is what they do sometimes on these appeals, is that they cherry pick the information. They don't necessarily have any obligation to send it to another doctor to review. They have no obligation to have you assess. They have no obligation to send you to treatment. It is literally a process they've conceived of internally to allow them to keep you in their little loop and to just keep sending you letters saying no. But if you don't agree with us, please send us more medical information, and you know what? We'll take another look at it.
Right. So first question was it an appeal? We got that one down. Number 2, should you always do it? No, generally not. Number 3, is there any other way to get the LTD benefits if the insurance company rejects your appeal or appeals more than one, right?
Yes, absolutely. And it's that legal claim.
Yep.
And it is really a very effective and efficient tool. This is why we don't go down the path of the appeal, John, is because we've had such a huge degree of success starting that lawsuit and leveraging everything against the insurance company. Our process is very simple. You retain us, we take all the stress away, we will deal with your doctors, we will deal with the insurance company, you can focus on your health, right? And it is such a stress reliever for people when we do that, instead of the appeal process where they're stuck doing everything. In fact, adjusters will say to people, it is your responsibility to submit more medical information for us, and you pay for that medical information. When we deal with that, John, we will fund all of that, we will take care of all of that for a claimant. And we know what to put in our legal claims and what those pressure points are with the insurance company to get a fast and excellent result for our clients. And this is why the appeal process is so frustrating, is that it discourages people, it wears people down, and at the end they feel like they have no other options, instead of coming to us early and allowing us to help them through the legal claim.
Now you know the appeal process. Now you know. So reach out to Tamar anytime you don't want to continue that. If you're in that situation, we're going to get to some email as well on the other side of the break. So stick around for that here. In the meantime, that number 1-855-821-5900, help at disabilityrights.ca. We'll continue more of the Disability Law Show just ahead.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Disability Law Show, welcome back. Good to have you around for the half hour. I mentioned email. You want to send one along anytime, whether it's for air or otherwise. You could do so, help at disabilityrights.ca. Tamar, it's Brian this time around, says, I've been on LTD for nearly 2 years due to a serious heart condition. Recently, a co-worker mentioned that our company might be facing significant financial troubles. If the business shuts down and I lose my job, will my benefits be affected? Common question.
It is a common question. And so what does benefits mean in this question, right? I think that's where I want to start with this, John, and Brian's asking a very important question. And so, as I said, I think at the top of the show, LTD benefits shouldn't be impacted if your company shuts down. Your LTD claim, if you are on claim, has already crystallized. What does that mean? It's already been secured with your right under that policy that may have existed between the insurance company and your employer for your entitlement to that, Brian, under that policy. And so why do I focus on that? Is because that group plan may have other benefits for you other than LTD. You might have extended health, dental, life insurance coverage. And so if you are no longer employed, you likely don't have access to those benefits. And so, John, when people are on disability, naturally they need those extended health benefits to access treatment. Right. And I think that's the biggest trouble in Brian's situation, is that he may now not have access to those extended health benefits, and then what's that going to do for him accessing treatment? He may be out of pocket for that. And so that is definitely something that's of concern for sure. And, you know, is he entitled to some kind of compensation if the business closes down? There's all sorts of employment questions that are coming into my brain, but really just focusing on the disability one for now. The other aspect of this for Brian is that he's been on disability, he tells us, for nearly 2 years. Well, we know that most disability policies have a change in the definition to continue to qualify for LTD benefits. So insurance companies have set this up. They've set it up in a way where they will typically have people on claim for a couple of years on the basis that they're totally disabled from their own job, their own occupation. And then after those 2 years are paid, or 24 months, then the definition changes. And it arguably becomes tougher to meet. And it says in most policies, are you totally disabled from doing any occupation? Anything in the world for which you've got minimum qualifications, education, and training, and that would pay you roughly what you were making on LTD, so 2/3. And so you can see the threshold of earnings is lower and the test to qualify is tougher. And so when I see a profile like Brian's, it can be very difficult to navigate not only losing your job, losing your extended health benefits, potentially losing a treatment provider that was supportive of your disability claim, and then having to prove, John, on top of everything else, that you still remain totally disabled from not only your own occupation, but from any occupation. And so this is a lot to navigate. I grant Brian that. But it's important that he's reached out to us so that he knows, look, where do I go from here? And so in theory, if his doctors are still supporting that he's totally disabled from working in any setting, then his LTD benefits should continue regardless of his company having financial difficulties and potentially him losing his job as a result of that.
Because he could be on for years and years if it's that severe. The company could be long gone at that point, right?
That's exactly right. And John, the LTD policy doesn't necessarily go away.
Yeah.
That's the relationship and the nature of these group disability plans, is that it doesn't necessarily mean that the employer has to exist if contractually that policy was there and was there to respond to Brian. And so if this goes the way that I think it might go, which is company shuts down, insurance companies now not getting premiums for this, and now they're getting a little aggressive at the change of definition, he might be getting cut off, but may still be entitled to LTD. Right. And we help people like this all of the time to get the compensation they deserve. And that compensation is, the starting point would be the disability insurer.
We'll get to one more question. This comes from mydisabilityquestions.com, available for you anytime, free and anonymous. Eleanor says, speaking to my insurance adjuster seems to increase my anxiety and stress. Is it possible to ask for less frequent updates from them? I'm worried that by avoiding communications, my LTD benefits will be cut off.
Look, this is one that's difficult because there is an obligation for adjusters to ensure that they are releasing that LTD benefit month over month. It is a month-to-month benefit. So there will be contact with the adjuster, and that contact can be monthly, sometimes more, ideally less though, right? And so when you've got a profile like Eleanor's, where you're getting increasing symptoms, health issues as a result of your contact from your insurance company, that is a situation in my mind that is absolutely fair to say, listen, adjuster, it's not that I don't want to speak to you, I just need to put some limits around the amount of contact that we have or when we're going to speak. So I've given this advice to other claimants many times. If your doctor can support that you need some limits placed in your contact with your insurance company, that is absolutely a legitimate reason to say to your adjuster, we need to schedule these, they need to be once every whatever month. If you need other updates, can we do it via email? That is absolutely fair, especially if it's a mental health disability, John. So imagine if Eleanor's conditions are based in anxiety, and now you've got to talk to the adjuster every month and try and prove to this person time and time again, yep, no, I'm still sick, yep, no, I'm still doing treatment, right? It is very, very challenging, but one that is a bit par for the course because of what I said about it being a month-to-month benefit. But it is absolutely fair to put those limits if you have the support of your doctors to do so, and it's absolutely fair to do that in this kind of context.
And again, just before we go, if you do get cut off and you file a claim, you guys take over? Silence.
Silence.
Nice.
The calls stop and they become our problem happily.
Yeah. There you go. We're just about out of time for this week. Thank you so much. If you sent in an email or went to mydisabilityquestions.com, continue doing that. We love getting the correspondence. Join us on one of our radio shows if you can. Simply go to disabilityrights.ca to find a station near you. Pretty much across the country where we do hour-long plus shows. Myself and Tamar and James, everybody's on board. And we always have ask you anyway to contribute to that show. As we get out of here for today, I'll give you the phone number a couple times, 1-855-821-5900. Again, 1-855-821-5900. The email address always help@disabilityrights.ca. And don't forget it, pocketdisabilitylawyer.ca. It's free, it's anonymous. It'll answer some questions for you as well. We'll catch you next time on the Disability Law Show.